Okay, good morning, St. Louis. How are you? Doug Portnow here. If we could just go to slide 2, please. I'll just go over a couple of administrative things before we get started on today's presentation, Intellectual Property Strategies for Executives and Entrepreneurs. We will be recording today's presentation. And if you're interested in getting a copy of or getting a link to the recording or copies of the slides, please visit our website, slwip.com, and you'll be able to find that information. And if you can't, we'll provide our email addresses at the end of the presentation. Feel free to email us with any questions or ask for the link or the slides. We'd be happy to share them with you. A couple of other administrative things today. If you have questions, feel free to type them in the Q&A box, and we'll try to address them either real time or at the end of the presentation. If you have any general chat type of things that you want to share with the group, feel free to type those into the chat box, although we won't be actively monitoring the chat box. And finally, if you're interested in more IP related topics, feel free to follow us on LinkedIn or our website, slwip.com. And just to get us started, make sure everybody's awake and warmed up, feel free to comment on whether you like what your favorite St. Louis barbecue is, whether it's Pappy's, Salt and Smoke, or Bogart's. Definitely love to hear from you. So next time I'm there, I know which restaurant to hit. And let's introduce our speakers. I'm your host, Doug Portnow. I'm a registered patent attorney at the law firm Schwegman, Lundberg, and Woosner. I'm excited to announce that next semester I will be adjunct faculty at the University of Hawaii Law School teaching intellectual property. So I hope to see you at my class. And I worked at a couple of big law firms previously. And my background is in mechanical engineering and bioengineering. And my practice primarily focuses on mechanical and medical device inventions. Before entering law, I did work as an R&D engineer for many years in the medical device industry. And just a random fun fact about myself, I once helped change a tire on a 747 airplane. So just something to share. Our next speaker is going to be Ryan Connell. Ryan is also a registered patent attorney at the Schwegman Law Firm, and his practice focuses mostly on chemical engineering, material science, biotech, and organic chemistry. He also does a lot of mechanical and electromechanical type of inventions. And Ryan's background as his law degree is from the University of Minnesota, and he has degrees in organic chemistry and chemistry from the University of Minnesota. And in his spare time, he's a volunteer with Wills for Heroes program, which sounds like a very exciting and helpful thing. And just a random fact about Ryan. Ryan is actually a merchant mariner, and he's licensed to captain 100-ton ferry boats on Lake Superior. And our third speaker today is Lynn Nguyen. Lynn is also a registered patent attorney and a partner at the Schwegman Law Firm. Lynn focuses mainly on software and electrical engineering inventions. And her law degree is from Chicago, Kent. And her undergrad degree in engineering is from McGill up in Montreal. So bonjour, Lynn.
Hi.
All right. If we move on to slide 6, just a real quick overview of today. We're going to be talking about IP, what it is, who owns it. We'll touch briefly on freedom to operate and patentability analysis. And we'll also talk a little bit about portfolio management, cost control, IP, and how it relates to due diligence during fundraising or exit strategies. We'll talk very briefly about some patent valuation models and some analytics. And with that, I'm going to turn it over to Lynn, who's going to talk about the various forms of IP. Lynn?
Hey, so I'm going to do a brief overview on these types of intellectual property. So these different types of intellectual property we include trademarks, copyrights, which are often referred to as soft IP. And then we also have trade secrets and patents. We're going to dive into each one of those. So next slide, please. Trademarks. What is a trademark? A trademark or a service mark is a word or phrase, symbol, and or design that identifies and distinguishes the sources of goods or services of one party from those of others. So if we're looking at these examples, you have McDonald's Golden Arches with the words McDonald's, Colonel Sanders and KFC, When we see these marks on our burgers or on our buckets of chicken, these marks let us know as consumers what company is the source of the product. Trademarks can also be given to colors, sounds, and smells. Colors, examples of colors are the Tiffany blue, the UPS brown, Home Depot orange, John Deere green. Don't confuse the term trademark with ownership of color though, because trademarking a color simply allows a company to use a particular combination and shade of color in its own industry. What are examples of sounds? The NBC chimes was actually the first sound to be trademarked in 1950. Other examples are the MGM Lions roar, the 20th Century Fox fanfare. Yeah, these are each, and the THX deep note by Lucasfilm. Those are all sounds that when I even say them, I feel like we can all hear the sounds, and that's why it makes it attributable directly to that company. Smells, the classic example from law school would be the embroidery thread that smells like plumeria flowers. But looking into anything new that was trademarked as terms of smell, we have a flowery musk scent in all Verizon wireless stores that got a scent trademark in 2014. So apparently Verizon plans to pump this trademark scent into their larger marquee retail stores, and their application argues that the smell would actually help them distinguish these locations from other communications and consumer electronic retailers in an increasingly crowded field. Didn't know that, but we should go check it out. Next slide, please. So copyrights. A copyright protects original works of authorship for an expression fixed in a tangible medium. That includes literary, dramatic, musical, and artistic works such as poetry, novels, movies, songs, computer software, and architecture. So a question for the audience would be, can you copyright a dance move? And this is something that's coming up a lot lately. The answer really is yes and no. So yes, in that dancers and choreographers can copyright moves as long as they're fixed in a tangible medium of expression, meaning that they're publicly known in a movie or a video. In 2018, a lawsuit was filed against Epic Games, which is associated with Fortnite. The lawsuit claims that they're stealing and selling dance moves in the video game. So in Fortnite, for those who don't know, you can buy dance moves for your characters. And you can just buy them online that way. One of the dance moves that was at issue is the Alfonso Ribeiro's Carlton dance from Fresh Prince. That also ages me, but anyway, the question is whether the move was fully formed enough to constitute an intellectual property. So short sequence of dance moves may not be good enough for copyright. And the newest update to this case is that currently a new Supreme Court rule requires that a copyright be granted by the USPTO and not just an application filed, which was the previous standard. And very recently, unfortunately for Carlton, the USPTO ended up denying a copyright for his Carlton dance. With that, it'll be really interesting to see how copyrights will apply to dancers and choreographer content for content creators on TikTok. I mean, that is also publicly known in a video or movie, but again, we'll have to figure out whether they can get copyrights and whether their move is fully formed enough to constitute IP. So next slide, please. Trade secrets. Trade secret is anything that you can keep a secret as long as it lasts as long as you can keep it a secret. So for instance, this can be a manufacturing process, a client list, a formula. The examples are the Coca-Cola recipe, KFC, again with Coca-Cola and KFC. KFC is a secret blend of 12 herbs and spices. Google search algorithm, McDonald's Big Mac special sauce. These are all trade secrets. We don't know what's in them. Pros and cons. I guess as a time is a pro is a pro for trade secrets in that there's no time limit to the amount of time a trade secret is protected. It's just basically as long as you can keep it a secret. For patents, I guess the con is that you have a limit amount, and it is 20 years for a utility patent, 15 years for a design patent. Public disclosure. In patents, we have to disclose the invention in exchange for a 20-year patent term. So I guess it's a con. Enforceability, however, for patents is that's the pro, where if someone else is using your invention, you can enforce your patent, but you can't do that with a trade secret. Next slide, please. So finally, we have patents. The different types of patents include utility patents, which can be for a machine, a process, an article manufacturer, composition of matter. This is the most common type of patent. Design patents, which is for ornamental designs. Examples are like the rounded corners of the iPhone that the jury found that Samsung infringed and gave Apple $1 billion. The SCOTUS did reduce that amount though. Finally, we also have plant patents for plant varieties that are asexually reproduced. An example of that is the house avocado, but more recently, in 2019, we have hemp plants. Hemp plant named CW2A is the first hemp plant patent to be awarded. In other countries outside the US, Canada, and the UK, they also have utility models, sometimes referred to as a small patent. These are easier and cheaper to obtain, and they provide a shorter term. So today our focus will be on patents, and I'm going to pass it on to Ryan.
So understanding what a patent is helpful to understand how you can leverage it best for your company. What a patent does is it gives you the right to exclude others from making, using, or selling the invention for a limited amount of time. Typically, that amount of time is for a utility patent, you're looking at 20 years of exclusivity from the filing date of the patent. The trade-off for getting that exclusive amount of time is that you have to write your patent in a way that allows people to make and use your invention. So the trade-off really comes in that you're getting an exclusive window, but you're giving the public enough information so that when your invention comes off patent, the public can benefit from that. But during those 20 years for a utility patent, you have the complete right to stop others from making, using, or selling your invention. One thing that's a misconception about having a patent, however, is that some people think that if you have a patent, that you automatically have the right to practice the invention in the patent. That's not necessarily true. You can think about an instance, say, in the pharmaceutical realm, where you might have a patent that covers a drug. However, before it goes through regulatory scrutiny, thinking FDA approval, for example, you can't actually sell your drug just because you have a patent. So once you do have a patent on something, you need to look into whether you can actually, in fact, use it. Another thing that we'll touch on later is in the sphere of freedom to operate. Sometimes you might have a patent, but your invention might, in some cases, actually be covered by a broader patent that was out there first. So keep in mind that just because you have a patent, you might not be able to use your invention automatically. Having patents are important, and there's a lot of very, very good reasons to obtain one. For starters, the right to exclude others from making, using, or selling your invention. It's also, patents are also an asset in of themselves. They're a form of property, and they can be monetized. You can take security interests against your patent. You can sell your patent. You can get money by licensing your patent. You can do quite a bit of things. Even if you're not monetizing it directly, having a portfolio of patents is a way that you can help to increase your company's valuation. Oftentimes, investors like to see a patent portfolio or see a patent portfolio in progress that speaks to having the promise of having that exclusive window of exclusivity to cover the product. It also is a good way of showing people that you actually have something that is marketable in your company. To get a patent, it requires you to describe your invention or your product with enough specificity that the patent office considers your invention to be in your possession and enabled for it. So what that means is that you have a product or an idea for a product that's developed enough that it actually could be, in fact, made. So it really helps to show folks that you have something in your company. And also, if you're in the early stages of your company, patent might really be one of your chief assets that you have. If you haven't, again, thinking of the pharmaceutical realm, if you haven't gone through the rounds of clinical studies yet, or you haven't done too many modifications on a lead molecule or sales or whatnot, the patent can be a early asset in your company's growth to show folks that you're serious. As far as obtaining a patent, to get it, you need to file a patent application, and you need to phrase your patent application and claims in such a way that you articulate an invention that's novel, meaning it's never been done before, non-obvious, meaning that even if what you've done hasn't been done before, that the gap between your invention and what's out there is significant enough that it wouldn't just be considered an obvious variation by the patent office. And finally, that your product is enabled, meaning that you're able to articulate it with enough specificity to convince the patent office that you could, in fact, reduce your invention to practice, be it with words in the application itself, or actually build the product. Once you do have a patent or an application pending or build up any type of intellectual property portfolio, it's important at the outset to make sure that you have ownership and assignment squared away. Patents in the United States, a patent is automatically, ownership is vested in the inventors themselves. Now, if you're a company, like a couple person company, that's usually okay. Oftentimes, an owner can be an inventor, but as a company starts to grow and you have people working for you who are in R&D, the patents that might issue from their work are automatically going to vest in them. And if you needed to get to your company in the United States, you have to take the extra step of having the inventors assign their ownership interest to the company. It's something that can be done for each invention. You can have an assignment document prepared and filed. It's something that you can also put into an employee's contract that indicates that they're obligated to assign rights and IP that they developed during the course of their employment to the company. But it is something that for each invention, you're going to want an assignment recorded, or executed rather, and then recorded. Recording meaning that you file that assignment with the patent office. It's akin to recording a deed to property in your county's register office. That's something that you really need to do to put the public on notice as to who owns the patent that's out there. When you do prepare assignment documents, make sure that you prepare in a way that's broad enough to include patents that are part of the family. That is, if you have one patent and then you file other patents based off of that one, called continuations or divisionals, you want to make sure that assignment language accounts for that, so that as the family expands, the assignment that you want is actually affected. If you don't have your ownership tidied up, it can open you up to risks in enforcing your IP assets. It could, in some cases, open you up to patent infringement suits. And it also, just if you're trying to monetize your patent portfolio through getting investment in your company, if your portfolio just doesn't look like it's airtight as far as ownership goes, it can actually scare some investors away. Some tips on getting assignments: the sooner you get them, the better. Inventors can change jobs frequently. Some might become disgruntled later on and not want to sign, although there are legal mechanisms available to make them sign or to deal with it. But it's just doing an assignment is wisest to do concurrently with filing the patent applications. When you have everybody's attention, people's spirits are high, and it's just good to get it ironed out right away. And also, whenever you do get assignments executed, again, it's best to record it same day or day after. Again, just to keep momentum going and make sure that you have everything wrapped up before you forget about it. As your portfolio grows, it's a good idea to keep monitoring this. Go back through your documents and make sure that assignments are where you want it, that the assignments spell correct entity names, correct inventor names, addresses. It's just good to do. And it's especially good if you're getting into the process of actually doing significant fundraising or looking to sell your company. One of the things that will certainly happen is an IP due diligence will occur on your patent portfolio. And it's good to make sure that you can iron out any issues before that process gets kicked off so that you're putting yourself in the best position possible. Just one last note on kind of backup or a catch-all to help you to make sure that assignment is proper. I mentioned before about putting into an employment contract that your employees are going to be obligated to assign rights in their inventions or to the company. That's really smart to do, not just with your employees, but if you bring in outside consultants or a contractor or anyone who might be involved in developing IP for your company, you want to make sure that contracts you have with them indicate that your IP needs to be assigned to that company. It can save you a whole lot of trouble later.
Can I jump in with a question, Ryan, real quick?
Sure.
So one of the questions our audience has asked is, can a UCC filing provide sale or assignment of a patent? I'm sorry, can a UCC filing prove sale or assignment of a patent? Do you want to take that? I have a few thoughts that
Yeah, why don't you go ahead, Doug?
Okay, well, sure. So the idea behind recording an assignment is to obviously demonstrate to the public that the assignment has occurred. So UCC filing, I believe, would suffice as in terms of public disclosure of that. But typically patents are actually recorded at the PTO recordation database. So it would be a little bit unconventional to record this as a UCC. And typically UCC filings are more for liens and things like that I see. So I think you can do it, but again, the convention would be to record these things at the PTO rather than with the state.
So to discuss what claim, go ahead.
Yeah, sorry. So patentability, what sort of claims can I get? In a patent, the claim section is what we argue about with the USPTO, and it delineates the metes and bounds of what's yours. So claims, what we want is claims that are broad enough to, as broad as possible, to block as much as you can, but we don't want our claims to be so broad that they're vulnerable to invalidity attacks. We also don't want our claims so narrow that they're invulnerable to invalidity attacks, but only cover your commercial embodiment and nothing else. So the sweet spot is somewhere in between, and we want to consider a range of broad and then narrower claims as well. I guess we can walk through an example about this. So as an example, let's say you have a social media company that have inventions that generate filters based on geolocations. For example, if you're at South by Southwest Music Festival, they might generate filters for South by Southwest while you're at the South by Southwest Music Fest. So what will my claims look like? You don't want your claims to be so broad that you're claiming all camera devices that capture selfies, but you also don't want to be so narrow that you're getting a patent on just South by Southwest filters. So somewhere in between would be something like a geolocation within a radius that determines like what events are happening. And then maybe based on what events are happening, they'll generate filters on that. That's just a quick example, but yeah, we want to find something that is relevant to what we're making, but also not be super broad. So next slide, please. You should know your prior art, I guess. This helps make sure that, so what sort of claims should I get? We should also make sure your claims cover your commercial product, target a competitor's device or a likely design around. You should know your prior art. This helps in your patent prosecution so that you know what's out there. I know that when I want to write more detail around my claim elements. For example, it's like if I want to differentiate myself from something that is out there, I just have to add all the details that's necessary in order for me to kind of draw back into that to draft claims appropriately. This will also help us in due diligence. If your claims in your spec are clearly written with the prior art in mind, that helps us figure out like where that you kept that in mind when you wrote your application. You can also map your claims to a commercial product or a competitor's product. So you can go see what your competitors are making. And if we have a better priority date on our application that covers this, we can file continuations with claims that are capturing what your competitor is doing. So again, you map your claims to your competitors, your commercial product or your competitor product for targeting, and your claims should cover your most important features. Next slide, please. What can I patent and what should I patent? You can patent anything human-made under the sun, but you cannot patent laws of nature, naturally occurring things, and abstract ideas. What are these things? So abstract ideas include mathematical or algorithms, organizing human activity, and that includes managing personal behavior or relationships or interactions between people. And then mental processes is another example, and that would be concepts performed in the human mind, including observation, evaluation, judgment, opinions. Laws of natures or natural phenomena, that's things like photosynthesis, so we can't patent those either. What should my patent portfolio cover? We try to get a wide range of claims. This includes device claims, medical or computer method claims, manufacturing claims, system claims, computer readable medium claims, composition of matter, product claims, that we really try to span the gamut in order to capture everything that, every different embodiment that your invention could be about. So next slide, please. What should I avoid patenting? If there's no commercial value, then you shouldn't be patenting it. If you don't think you'll ever practice the invention, again, maybe not something you want to patent. If you don't think your competitor will ever make the invention either, none of this, or if something doesn't make economic sense, that's just not worth spending the money on doing a patent. This again is a per company assessment. This could be based on your budget and what your goals are. If you have a big budget, you are able to cast a much wider net. If you're a smaller patent budget, then you should be selective about your filing strategy and pick the most important innovations that are relevant to your business. When do I file a patent is a super important point in the US and abroad. So in the US, like most of the world, we're a first to file system. So file sooner rather than later. You can also file provisionals and update them for inventions that are not fully baked. In the US, we have the possibility of filing a provisional application as soon as you want. And then you have 1 year to convert it into a non-provisional application. We can also file multiple provisional applications that are then all kind of converted into one non-provisional application as well. So that's always a good strategy. And then the provisional applications are a lot cheaper, but it gets your foot in the door and you'll also have like that filing date on hand. I'm going to pass it back to Ryan now for FTOs.
And if I could just follow up on the last question about recording UCC assignments. One of our audience members has corrected me that actually the law states that assignments are to be recorded with the PTO. So to correct myself, you would want to record those at the PTO, not as a UCC statement. So thanks, Jonah. I know this person. I know he's very, very thorough and reliable. So I think that's good information. I didn't have the code in front of me. Anyways, back to you, Ryan.
Of course. So freedom to operate. Freedom to operate's really important for assessing risk. So just like if you have a patent, then obviously you have the right to exclude others from making, using, or selling your invention. Freedom to operate assesses the risk that somebody else might have a patent that prevents you from practicing, making, using, or selling a product that you might have. So as you're developing your product, whatever it may be in your company, once you've kind of started to land on what your final product may be, that is, once you know what the features are that makes it tick, once you're pretty much about ready to start going forward with that product exclusively, it's smart to engage an IP firm to take that product and then go out and do a search for patent literature that might impact your ability to make, use, or sell that product, namely to see if there are patents that cover it. If you go through that freedom to operate study and find that there aren't patents that you're aware of that impact that right, then you're that much stronger going into market, knowing that the risk of having a patent infringement suit, or at least a meaningful patent infringement suit assessed against you, is minimal. And this, again, is something that investors oftentimes like to see before they invest in a company to evaluate that risk. Conversely, if you do a freedom to operate search and you find that there are patents out there that are problematic, it's not necessarily the end of the road. You can use that information to look to do a design around in your product. Maybe there's a feature that is that causes infringement issues for the patent that you found, but tweaking it in your design actually doesn't make that much of a difference in your performance. So it's an easy enough tweak. Also, just because you find a patent that appears to be dead on to your product, you have options of actually digging into that patent to see just how strong it is. Is it actually valid? Could it be knocked out in some way? There's a lot of things that you can do. You could even go forward and have an attorney prepare a opinion of non-infringement that might come in handy if there is a patent infringement lawsuit assessed against you in the future. It's just a really good way of knowing what's out there before you launch your product. The ideal timing to do that, again, is when your product is relatively static. If you do it too early in the development, then you're doing an FTO on a moving target, and the FTO that you might do early might be irrelevant if you go through a redesign of significance. So it's you really, the timing on it really has to be when your product is somewhat static. Sometimes you can do early on a preliminary FTO analysis. That's kind of more, you might hear that referred to as a landscape search, where you're just where maybe your product isn't fully developed, but you have an idea what it might be. So you just kind of do a cursory search of the patent space in general in that tech field, just to get a flavor for what might be out there. That's something you can do too. But the FTO analysis is a really important part of your product launch. I'm going to turn it over to Doug to discuss some of the aspects relating to IP due diligence now.
Okay, thanks, Ryan. So before I start talking about diligence, thanks for all the questions. Keep them coming. Let's see, Lynn, there was a question. I'm not sure if you addressed this, but the question was, if an algorithm is part of a software, is it still an abstract idea? To the extent a patent is a set of instructions, isn't it an algorithm? Maybe you could talk about that a little bit.
I'm happy to. I'm glad that you asked live, so I didn't have to type it out. That is a tricky question. It is also, for our purposes, I would say that it is not an abstract idea. Like we try to write applications all the time for software, and of course, algorithms are a big part of software, and it doesn't render them an abstract idea. There's a lot of different strategies to address potential rejections under 101, and we'll probably talk about this later too. But Alice was the decision that made it very difficult for us to claim that we have to do more steps to claim that software applications are not abstract. The USPTO has provided a lot of guidance since the time that we filed, since Alice, in order for us to kind of try to capture to make them not abstract ideas. Among other things, you can put them into, well, first you have to make them non-tangible. So you would actually you would have to make them tangible. You put them onto, you store them onto like computer medium, just in order to make that outside of the world of like human mind activity stuff. But aside from that, we're doing other things now, like with regards to trying to tie it to practical applications, making these algorithms do something concrete, and that would actually bring it outside of the abstract idea realm. Hope that answers.
It's another software question, if you want to take that, Lynn. It says, I built a software called To Do using the domain mytodoo.com, knowing that there is already a website called To Do using todo.io. everybody wish me luck when they no doubt find out and want to fight me over LOL. So I'm not sure what the question is.
I think that might be at one point for the domain name
Yeah.
contrast, maybe a trademark problem. Yeah, we'll have to circle back, but good luck.
Okay, well, good. Keep those questions coming. Type them in the Q&A box. We'll be happy to address them to the best of our ability. So we've talked a little bit about, getting patents to protect your inventions or block third parties. We've talked a little bit about ownership of those patents. We've talked a little bit about patentability, what kind of claims you can get. We've also talked about freedom to operate, your ability or your avoidance of infringing a third-party patent. So when you start putting all of those things together, you start getting an IP portfolio, you start getting an IP story. And where that story becomes important is in terms of IP due diligence. If you're a startup company, as I know so many of you are, what do you need? You need capital. You're going to go out there and you're going to be raising Series A, your seed, your Series A, your B, C. You may go public, or maybe you're going through an exit strategy with a large strategic. And guess what? Those opposing parties are going to want to do some kind of IP due diligence on your IP portfolio. They want to check out your story. Do you own the IP? How well do you protect your invention? Are you infringing somebody's patents, et cetera, et cetera? They want to minimize risk. And the way they want to minimize risk is they want to check out your IP story. Is it good? Is it solid? Have you done your homework, or does it have a lot of holes? Are they going to be investing money in you and guaranteeing buying a lawsuit? Obviously, they don't want to do that. So that's where this process of IP due diligence comes in. So what is it? It's reviewing your IP portfolio, your IP positions, your analyses during fundraising or an exit event, such as a merger or acquisition, or any type of review of your IPO by any third party. And the bottom line is you want to create a credible story to address your IP. And that amounts to risk management. And I'll tell just a very brief story. I think when Volkswagen bought, was it the Jaguar or Bentley lines? I can't remember which automotive company, but they did a lot of due diligence. But one thing they forgot was to actually find out who owned some of the trademarks for that luxury automobile line. So the deal went through, they bought the car automobile line, but they didn't get the trademarks, so they couldn't mark the cars Bentley or, sorry, it was Rolls-Royce. They couldn't actually brand their cars with the Rolls-Royce logo or the Flying Lady hood ornament. And that created a huge problem. They had to do another deal. So somebody did not do the proper due diligence on that. Let's move ahead to the next slide. So as I mentioned to you, there's a process involved in that, and how do you prepare for that? Well, there's going to be an opposing party. It may be lawyers, it may be the business development folks. It could be anyone, but basically it's quite fair to ask them ahead of time, okay, what do you want to know? A lot of these people have a standard list of questions. I myself, when I'm diligencing a target, I have a standard list of 4 or 5 page questions that I will ask them. And I think pretty much everyone has the same list of questions, but it's quite fair to ask them for that. And that'll give you time to prepare and do your homework. Some simple things that you can do to definitely help yourself are make sure you have a master list of all your IP ready to go. If you can't even provide that list up front, that's a problem because you don't know what your IP is, and it makes you look, disorganized. Definitely use a data room because there's going to be a lot of documents that people want to look at. So have a space that can be easily accessed by people. And there's varying levels of control. If you use some of the paid sites, they can control what's accessed and what's printed out, and they keep a log of who looks at things. And other people just use simple Dropbox for these types of things. And then all the stuff that I just talked about, make sure all the assignments and licenses are up to date, do the audits that Ryan talked about, make sure you're aware of the prior art, be ready to address patentability and freedom of art, meaning distinguish your invention from the prior art. And if there's other, issues that you have concerns about, don't try to bury them, because we will find them during due diligence. Things that come up often are, disgruntled ex-employees who filed their own competing patents or patent applications, or maybe they're not signing assignment documents Maybe you receive a nasty gram, a cease and desist letter from the competitor, threatening to sue you. Maybe there's ongoing litigation. So again, you need to be ready to address all of that stuff and explain all of it and have a good story for that. So that's just kind of a real quick overview of the IP due diligence process. And it is important for startup companies who are going to be, going out and seeking financing or going through an exit strategy. And with that, I'm going to turn it over to Ryan, who's going to sort of talk about some portfolio management techniques.
Yeah, so once you start to build up your portfolio, it'd be nice if you got your patents issued and that was the end of the story, and they could just kind of sit on the shelf and bring in income. But patents, once they're accepted, there's actually some stuff that you have to do. You have to actually pay in the US, they're called maintenance fees, which you pay periodically throughout the lifetime of the patent to keep it in force. And if you don't pay any of those maintenance fees, then your patent will actually lapse before the term would otherwise end. In Europe, they're called annuities. So you have to make sure that you go through your portfolio, make sure all these fees are up to date and that they're going to be paid. And also to that end, you want to reevaluate your portfolio from time to time to see if the patent is still valuable. It's not uncommon that sometimes, a patent, maybe its value is in the first 5 years of its life. And then maybe in 5 years, technology has passed it by, and then there's no point to keeping that patent active or paying the maintenance fees to keep it in force. Or maybe you don't want to do that, but you could license it to somebody who is interested in it. Who knows? But the point is that you do want to go through your portfolio periodically to assess what patents are really core to your business and which ones maybe make sense to let go for cost savings. And they are expensive too, not just domestically, but if you think about your plan to file internationally, every country has their own costs for filing the patent and again keeping it active throughout the course of its lifetime. And there might be times where you are a little overly inclusive at the time you're filing. Maybe you don't know what your market is for the patent, which countries will be important. But as your portfolio and your product matures, you can reevaluate and look for countries that maybe you can drop. Maybe you had a patent in one country because that's where a competitor was manufacturing something similar, but they moved their manufacturing to a different country, so there's no need for that patent anymore. Or if it's pharmaceutical, sometimes a particular disease or ailment will affect, one part of the world more than the other. And, maybe you drop patents as conditions change. Something like that. It's just something to keep in mind, that just because you have your issued patent doesn't mean that you don't need to go through and make sure that the patents are actually doing what you want, and not to be afraid to drop them when they're just not advantageous for you anymore. Another thing that you'll want to look at from time to time in your portfolio is, can you get any extension on the lifetime of your patent? There are things called patent term adjustments. Those account for delays caused by the patent office during the prosecution of your patent. Typically, the patent office does a good job of getting that squared away, but it's something to check from time to time, ideally before it issues or when it does issue and you get your adjustment calculation. But something you can check back and see if your patents are entitled to any extension. Also, there's some extension under Hatch-Waxman Act for certain drugs, medical devices. If you have patents directed to those, then you can look into that to try to get some extension on your term. With that, I'll turn it over for patent valuation.
Okay, thanks, Ryan. Yeah, so what I like to say about portfolio management is IP is like having a pet. Pets, you need to feed them, you need to bathe them, you need to give them tender loving care and attention. So IP is kind of the same thing. Don't neglect your IP portfolio. There are basically 3 models for valuing patents or intellectual property. And I'm gonna just talk about these kind of generically, because if you actually want to do this, then, it's a very quantitative exercise. There's a lot of assumptions and things made. And you need to hire an expert to do this. But basically, the three methods are comps, which is hard to do. There's the equivalent R&D cost, and then there's the discounted cash flow method. And what those are, comps is just like when you buy a house, right? You look for other houses in your neighborhood that have recently sold and have similar features, and use that to try to figure out, what the value of your house is. So same thing with IP. You try to find similar portfolios, similar technology, and use those to value what you have. And that's why it's hard, because, obviously you're talking about an invention, which by definition is unique, right? So how do you compare that to other inventions? But, and like something that I've seen in the mitral valve, prosthetic mitral valve space, a whole bunch of companies were recently sold. They were all very early stage. So most of their value came from the IP. So, possibly the acquisition price of those companies could be used to value the IP. And then the second technique is the equivalent R&D cost. So what does that mean? That means, well, you kind of do this paper exercise where you figure out how much it would cost to develop that technology. And then that would be the value of the IP, assuming that your IP really does accurately capture and reflect your invention and your technology. Again, it's kind of hard to do that, but it's a technique that we do see. And then the third and final method is the discounted cash flow. So if you've ever taken any business classes, you know what discounted cash flow is, which is where you project your future revenue associated with that product, or that technology, and then you discount it back using the net present value model, so that you have the current dollar value of that, and then that would be the value of that IP. So again, just a kind of a quick overview to let you know, people often ask us, okay, well, how much is my patent worth? And there is no right or wrong answer. At the end of the day, it's what the market will bear, right? So if you sell your patent for X dollars, that's what it's worth. But to get there, sometimes you need to do these three estimation methods, one or more of these estimation methods to come up with a dollar value. We do have a couple of questions, so I'll just take a little pause here. So we have one question about, if you file several subsequent provisional patent applications during development, when is the time to file the non-provisional application that will cover all prior provisionals? So the answer to that is 12 months from the earliest, the first provisional. So if you want to claim priority to all provisionals, then you go back to the first one. You have 12 months from that earliest date. Let's see. Then we have another question. Let's see. Doesn't the knowledge of other existent patents implicate that you are aware and that you potentially copied the idea? I've heard that it may be best not to dig too much to prevent you from being viewed as copying in the event that you go to court, so that it's best a law firm or service do the digging, but not an individual entrepreneur. Yeah, I mean, I've heard that, but knowledge is power, right? So if you know what's out there, you're going to be able to better distinguish your invention from what is in the prior art and be able to get better claims. Patents are intentionally designed to be publicly available. Once they become publicly in the domain, then you're free to use them. And that is the underlying principle behind the patent system, is for that limited 20-year period, you're disclosing your invention to the public so that they can use it once the 20-year patents have expired.
Can I jump in real quick, Doug?
Yeah, please do.
I also wanted to say, though, that you're right. Like I do, it is something that I tell my clients, like sometimes the inventors come in and they tell you, they're like, oh, we're going to start looking through all this stuff. You want us to look up things and dig around and see what else everyone else is doing? And the answer is no. Like I don't really want them to go in there and bring me all this like prior art, that then, because I do know, as it is our duty as attorneys, as patent attorneys, that we will then have to hand over all that stuff to the USPTO as well. So again, there is a balance of like figuring out what's out there in order to know that, what you're patenting is going to be not, right away rejected because You have other people doing exactly the same thing, but at the same time, we don't recommend that you go and, dig as deep as you can to figure out like what everyone else is doing or what's already out there as well. So I know it's kind of like saying both things and not giving you a clear answer, but I think it's somewhere in the middle, just like most patent stuff. Like don't go digging, but also knowledge is power. So yeah.
I completely agree with that. It's definitely a balancing act between knowing and not knowing. So there's no right or wrong answer to that, I guess. is the answer. And then the other question we had is going back to some of the valuation models. Do you include the R&D costs that may result in failures in search for the invention or not, and just include the success cost? So my response to that is it's a model, so you can build in whatever assumptions you want. But I think in reality, you rarely successfully invent something the first time. So it seems a little bit unfair if you exclude the failure costs. So to me, I think you have to put in a little bit of extra cost associated with some of these, trial and error type of things. So but that's a subjective thing. Okay, well, good. The next couple slides are just sort of best practices, and they're directed to specific technology areas. So I'm going to talk a little about mechanical and medical devices since I work in that area a lot, and then Ryan will talk about some chemical stuff, and then Lynn will talk about some EE software type of things. So if you're in the medical device or mechanical space and you're filing a patent application, the devil's in the detail. So you want to definitely describe your device in the patent application with lots of detail. You want to describe all the components, how they connect together, how they function, how they move relative to one another, their spatial relationship, et cetera, et cetera. And the reason is because sometimes it's those very subtle differences that allow you to distinguish your invention from what's in the prior art, and that will let you get a patent. So the devil's in the detail. So lots of detail for mechanical and medical devices is always, I guess I should never say always, right? But it's generally a useful thing to have. It gives you more ammunition for getting a patent. Another thing that we hear when we're talking about medical method or surgical claims is, why should I do them? They're useless. Well, that's I think not quite accurate. Medical method claims, they are patentable in the US, and there are at least one other foreign jurisdictions where they're patentable, although it is correct in most jurisdictions like Europe, China, Japan, Canada, those claims would not be patentable subject matter, so there's no point in pursuing them there. But the reason that they're valuable in the US and let's say Australia is because it allows, if you can't sue someone for a direct infringement, there are other legal theories called theories of infringement under indirect infringement, where you potentially could sue somebody who is using your medical method by inducing them or contributing to infringement. And there are some legal tests for that, which we won't go through today. But bottom line is medical method claims do have value certainly in the US. As Ryan mentioned earlier, under Hatch-Waxman, there are some patent term extension available for patents that will allow you to potentially get up to 5 extra years of life on your patent for certain drugs and medical devices. When you're dealing with mechanical or medical device inventions, a lot of times it's a very iterative process where you have sort of, generation 1, generation 2, generation 3 until you actually hit the design freeze stage. So we generally recommend filing provisional applications until you're really ready and you're happy that the design is frozen and you want that invention to be examined by the patent office. Again, choose international jurisdictions carefully. Don't file in countries that are small markets that don't have economic value, or it's not worth spending. For example, if you're going to spend, $30,000 to $50,000 to get a patent, are you going to spend that money in a country of 5 million people, or are you going to spend that money on a country that has very high per capita medical expenses and has a population of, hundreds of millions of people? So that's kind of the general comparison. And then again, just to reiterate what Ryan said earlier, make sure you get employee and consulting agreements that have IP assignment clauses in them. that's good backup in case people don't sign the assignment forms. And then, I deal with I'm based out of Silicon Valley, and a lot of my clients are early stage startup companies, and they're always going through fundraising or going through a merger acquisition and sometimes an IPO. So be prepared for IP due diligence. The better prepared you are, the better you do, the more likely you'll secure that fundraising and close the deal. Ryan, would you like to talk about some chemical best practices?
Yeah. So the chemical area is kind of thought of in the patent world as being a quote unquote unpredictable art. Those of us who've spent a significant amount of time in a chem lab kind of know how it goes, right? Reactions that really should work in theory, not uncommon for them to fail completely. Likewise, things that you wouldn't expect to work, son of gun, sometimes it just works and you get your compound and it has the properties you want. It's chemistry is fickle, as those of us in the field know. What that gives you though in the patent world is some really interesting latitude in terms of providing unexpected results in your data and in your claims, and really using that to leverage your way into potentially broad subject matter or really interesting claims. The key, though, to leveraging chemistry as an unpredictable art are examples. I don't know if I don't want to have my colleagues here disagree with me, but I think that in the chemical arts, having detailed working examples is probably more important than any other field in patent law. The reason is that if you really want to take advantage of saying that you have an unexpected or surprising result, you really want to prove it in your examples by showing what you did precisely and what the result is that you got. And there are quite a few ways to do that. It starts with being very explicit in what you actually made. And keep in mind that just because you have it very explicitly laid out doesn't mean that you're limited to that per se. But what it does is it gives you backup for your story of unpredictability, and it also provides, in a worst case scenario, an extremely strong fallback position for a specific compound. In addition to laying out exactly what you made, how you made it, and what it does, you're going to, in an ideal world, you'd want comparative examples. And the comparative examples might mean showing superior performance compared to another product that's out there. It could also include your failures. I tell my clients, we of course want to include your highlights in your examples. Don't forget about your lowlights though, because your lowlights, things that didn't work, and if you're doing chemical research, you're going to have plenty of them. They can show the criticality of what you're doing in your research and why it makes it work. As an example, I recently got a case allowed for a lubricant, and there was a very specific window of this one component, weight by weight percent in the formulation. And if you were outside that window, it didn't work on either side, above or below. And we were able to put in data from their R&D story showing that if you had that one component at X weight percent, it failed above and below that range, and we're able to show that criticality, and that ultimately is what gained us a patent. So really, it's data for the chemical practice, and once you have that data, you arguably are able to have a basis to expand your disclosure because you've articulated the concept of what's really making your invention hum, and then that helps you to grab more subject matter in your chemical claims. Use as much quantitative data as you can with ranges for weight percents, densities, anything you can think of. It really pays in the chemical arts to get as much quantitative data out there as possible. And then once you have your composition set, you can also take claims methods of using the composition. Think administering in the pharma realm, administering a compound to treat X. You can have methods of formulating it, methods of storing it. It's really quite infinite. So I'm sorry, I'm going through a little fast because we're running out of time, but just really, your options are really broad with the chemical arts, so long as you can have data to prove it, and that will put you in the best position to have a strong chemical patent. So I'll turn it over for best practices for electrical and computer.
Yeah, I'll finish up quickly. So for best practices on the electrical and software side, you should just definitely file your provisionals and non-provisionals early. Like if you have something that's not ready to go, but you have that idea down, you should write a provisional, and then we'll get that first filing date locked in. Early harvesting sessions with your inventors, set up meetings with your inventor groups, talk about what they're making, not necessarily have them tell you what they think is patentable, but like just have a rundown of like everything that they're making. And then, you can make those decisions as to like, or you and your patent attorney can make those decisions as to what it is that would make most sense for your business. So mining your inventions that are right for patenting. Don't forget about design patents and trademark. They're really valuable, and they often get overlooked when we're all just talking about utility patents, which is kind of like the big chunk. Different claims. You should think about when we write our patent applications, we need to make sure that like the claims cover the invention, but different types of claims can be used. You have in electrical and software, you have to think about what is your server doing, what are the client devices doing versus like what are the methods being implemented, and then those methods are the CRM claims as well. Like that allows us to kind of claim that everything, those methods or those algorithms or that software is being performed either in the server or in the clients or in that communication, but really trying to capture all those embodiments and all those aspects. And that also, the same applies for artificial intelligence, machine learning, neural network inventions. Again, we got to figure out like, where can all these things live? Like, how do we provision them? Like, these are algorithms that, you have to make sure are tied to, I guess that's my next point, like tied to improvements to your prior art system in order to make it Alice proof and like give it more concreteness rather than trigger the idea of it being an abstract idea into the examiner's minds. For Alice 101 rejections, how it's not the end all be all of like all of our software patents. You just have to draft your software applications to be robust against being rejected as an abstract idea and being called non-patentable. That means including patent practical applications and discussing the improvement of your invention over prior art systems. And finally, the USPTO provides us with a lot of examples as guidelines as to how to address these 101 rejections, what is non-patentable, versus what is patentable, and really just crafting your inventions around that as a guideline. So I'm going to pass it back for the next slide.
Okay, we're actually running out of time, so I'm going to just skip through this very, very quickly and just say there's a lot of information that's publicly available about technology, patents, inventions, et cetera, et cetera. I'm not even going to go through these graphs, but just to say that because there is so much public information, the use of analytics these days is a very powerful tool that can give you a lot of information about, what people are filing patents on, what the technology is, who the inventors are, the companies, when they file things, et cetera, et cetera. So, definitely take advantage of using some modern analytical techniques to collect, analyze this data. With that, Ryan, you want to wrap things up for us?
Yes, just briefly. So I hope from the talk you took away that patents are an important tool in your portfolio. They can help you not only to protect your invention, but also as an asset for fundraising or for your exit to monetize your portfolio. Don't focus exclusively on patents in developing your IP portfolio. There are plenty of opportunities to use trademarks, copyrights, and even trade secrets where appropriate. As you create your IP portfolio, try to keep it comprehensive. Try to show people that you've not only protected your inventions, but you're also positioned well from a freedom to operate perspective, as well as ownership, and that your patents are strong and that they actually are patentable should they be challenged. And finally, your portfolio is a live being. Make sure that you keep track of it, monitor it, and always ask yourself, how is your portfolio generating value, and how can it be streamlined to help to create more. So with that, I think there are just a handful of questions left, and we're happy to answer them. And thank you from all of us for your attention and joining us today. It's a pleasure speaking with you.
Yeah, we've definitely enjoyed being here and would love to get your feedback. If you can, scan the QR code on this slide and take the survey so we can know how we can improve things. We'd like to come back next year. Our email addresses are on the left. So thanks everyone thank you St. Louis for attending. And if you want to hang on for a minute, we'll address the last few questions. So the question that I see is, with the Chinese market racing to gather patents, are there are there key areas or details to consider to strengthen the patent protection? So I'll give you my 2 cents on that, and maybe Lynn and Ryan feel free to add. To me, as I've worked in China, to get good solid patents, you need to have China is very strict on what's called support, meaning you need to describe the invention in great detail. And then, so anything that you claim needs to be supported or described in the specification in the written part. So support is really critical for getting good protection in China. Anyone else want to add to that?
No, that sounds good. I think that it doesn't really change what you should be doing regardless of what China market racing to gather patents is doing. Like, you should have all the details gathered of your own invention in order for us to be able to draft a comprehensive patent application that'll be robust during patent prosecution.
Yeah, I would just add too that there's been in the past some folks are a little hesitant to enter China with their patents, but it really is to your benefit to enter. It's a good market to have patents on. The enforcement it's gotten a lot better as well. And if you also if you ever do have any inventors, any inventive activity taking place in China as your company grows, be sure to check with your patent attorneys about whether your patent application in its first instance needs to be filed in China. In fact, there are some instances where you need to get a foreign filing license from them that can impact your ability to get a patent in China later.
Well, thanks for that. Let's see, is that questions? If there are no, something just came in.
I'll answer that last question. I think it was about copywriting your software.
Oh yeah, sorry.
Yeah. So it was about copywriting, whether or not someone should copyright critical parts of their software in terms of IP protection. And I would say, like, copyright and patents provide different types of protection. If you are copywriting critical parts of your software, you're copywriting that exact code, right? Versus patents, where you're copywriting the idea of what your code is doing. You can, I would say, if you do want to copyright your software, yes, it's a good idea in the same way that you can do a wide range of patent protection, but keep in mind that you're obtaining a different type of protection. So you're actually protecting somebody from copying that exact code.
All right, well, good. With that, I think we'll wrap it up. Again, thanks to our audience for joining us. Thanks, Lynn, Ryan, and Michelle for helping us with the presentation today. And everyone have a good day. If you want a link to the recording or a copy of the slides, it'll be on our website, slwip.com. And hope to see you again soon. Bye.
All right, thank you.